welcome to this last session of the afternoon. We're going to talk about local standard evidence, when you need it, how you get it, what you do with it. And for this, again, we're lucky to have two guest speakers. I'll introduce Ian last on that basis. We have Thomas Ricard, known to many of you, a partner of JP Karsenty since 2017. Very often a foreign law expert in my experience, and well regarded in that way. He started his career at Linklaters in London, joined the Paris office, very involved in AIJA, I think, and involved in PIAPL. It says here, a member of PIAPL and AIDA, but I think it means AIJA. You don't actually. Yeah, I okay, and I noticed I went a little further than my assistant who put together your bio here. Your bio. How far did you go to? Your bio is still nothing. You are the ancien secrétaire de la Conférence du Barreau de Paris. The only reason I want to ask this question is a very personal one, not personally embarrassing, it's okay. A long time ago, I was chair of the environment in the Wales, and the Paris bar used to have a fabulous rentrée. And you used to stick very close to the deuxième secrétaire de la Jeune Barreau de Paris. Is that the same sort of position?
Exactly. I was number 7 in charge of communication with French speaking countries. And historically, the number 7 was supposed to be the Catholic lawyer of the group, the monk. Fortunately, it's not the case anymore.
Can you confirm that the deuxième secrétaire was very popular internationally because he or she was in charge of parties?
He is in charge of money and finances.
James Riley, an associate solicitor in the International Serious Injury Department, recognised as the Times Lawyer of the Week in 2021, and pursuing an important and outstanding case of the Irwin and Karsenty. What a great result that was. So again, thank you for coming and helping us out with this session and with this seminar. Ian Denham, you know everything there is know about Ian Denham, well, nearly everything. I'm not going to tell you. I'm not going to tell you. You don't know it's okay. He sits on the PIAPL board. He's secretary of the PIAPL RTA Whitlush. He's recently been led by Alex Wolf in a case involving catastrophic head injury for the RTA in Gibraltar. He was my junior in Johnson and Berenson, which is principally reported about the question of service of documents in Scotland, whether it's given by local law or not. Well, service of documents under Scots law. And if I may say so, I'm always proud to introduce you. He did pupillage in my chambers at King Street in Manchester. And I like to think I played a little part in becoming the trouble. So we're going to talk about expert evidence and local standards. And I got Christian that these three fabulous lawyers have put together for me. So I'm going to perform a little, but only in the sense of teasing out the parts that we're going to talk about. So if we're going to start a claim in a foreign country, we want to know whether we're going to win, don't we? Because we want to know whether it's a case that we can take on. And James, in England and Wales, very often it's going to come to your side of the question rather than mine. So what's your approach when you first get a claim, particularly if it involves local standards?
Well, I think it's really important to get input on local standards at the earliest opportunity. You obviously need to provide an expert like Thomas with something, so you need some form of documentation in order to get this initial view, but you need to get it at the earliest opportunity, pre-action, preferably before letter of claim is sent out. Yeah, so that's the approach that we take.
And how often are you looking at local standards as well as local law?
Very often, there's often an overlap. It depends on each case, Gerard, but there's often quite a substantial overlap.
And what sort of time constraints are on there? I mean, limitation, of course, is what type of
limitation. But you want to move as quickly as possible, especially with a very serious case. You want to progress things, so you move as quickly as you can. But that, as I said, that depends on what information is available to you when you're first instructed.
Well, I can remember doing a case called Bacon. It's my first case that I did with Sarah Prather. And in that case, as Sarah, as I recall, they changed the road by the time we came to look at it. And so we have to look back. And for instance, I put it forward as an example. You won't always, or certainly 12, 15 years ago, you wouldn't always have the same records in Spain as you might have from a highway authority in England and Wales. Is that the sort of thing one comes across?
Yes.
And as in any case, actually, you want to preserve the evidence and get as much contemporaneous evidence as you can.
Yeah.
Okay. And what do you do to begin with? Are you looking for a full report? Are you looking for guidance so you can assess the case?
I think it depends on the relationship you have with the expert that you're approaching. If it was Thomas, you can be a bit more informal because you have a relationship with Thomas and we can work together in a collaborative way. If somebody you don't know, you have to act a bit more formally.
And Thomas understands the English procedural rules better than most.
Yes.
Okay. And initial guidance, you don't want the full report. You want to know what's likely to come up and what the answers are likely to be.
You want to know what the issues are in your case, and you want to have preliminary answers to those issues.
Okay. And everything's come across your desk, from road traffic accidents to accidents, hotels, swimming pools, all sorts of things. Is that right?
Yes, and it's really important to know when you need local standards evidence. And the answer to that question is pretty much always. I was just listening to Sarah Jane talk about ex-impione and the circumstances involved in that case. And I'm sure everybody knows, but it's, as Sarah Jane said, it was a serious sexual assault, rape of a woman on a package holiday in Sri Lanka. Now, you'd think in that circumstance, a breach of the local standard is obvious. I wonder whether I ask a question to the room. Do you think you need to get local standards evidence in a case like that, or do you not think you need it? Shouldn't need it. It's not been answered to the question. Yeah. Would you get it? Would you not get it? Hands up for get it. Yeah, so the majority. We didn't get it because it wasn't an issue in the case. It wasn't one that was an issue in the case in the first instance, ex-impione. But I agree. I think you should get it in all circumstances, including in very obvious circumstances of that case.
And presumably, in technical cases, you want to get something in writing as soon as you can.
Yes.
This isn't on my crib sheet, so you may not have discussed it between yourselves, but let me throw it out twice.
If I just may add one point, before this, thanks a lot for having me. Okay, I haven't said that, but Gerard,
we're really pleased with
you. Sarah also, thank you. It's very touched by this. On getting the sort of informal view, this is sometimes done, but with two caveats. One is that usually it has to be formalized by an email. The second thing is that we are very careful when coming back to you of not giving you an advice. Okay, if it's a question like that, it happens quite often, and I think it's quite good because we've had this more and more in the past 10 years. And I'll come back to this because it's true that the relationship with barristers and with solicitors have changed drastically. And to be very clear, it's thanks for our firm, it's thanks to Sarah Prater, who 10 years ago was the first one who said, I want to have a meeting with the experts. And I want since the beginning. And that really changed the way we work. So it's true that it happened that you get an initial view just to make sure you're not getting in the wrong way. But we would be careful of when we provide anything, it's going to be something that would be in the report and something that is not an advice.
Okay. James, if you had a serious sort of traffic accident overseas, would you ever send out a UK-based accident reconstruction expert to go and look at that?
Yeah, it depends on the circumstances. Are you talking about in a package context, saying like excursion?
Not so much a package, but a more serious catastrophic incident.
Definitely.
Because then it's just a question of the English court being able to understand the dynamics of things.
Yeah.
And Ian, I think really I should be focusing on the package elements of this session. Okay. Just testing a little bit. And what information do you need, James, to get that to begin with? You want the basic information from the client.
Yeah, you need the basic information about the case and the cause of action. So what happened? Where did it happen? How did it happen? As much information as you can get in the first instance. But it's often the case that somebody who's injured isn't thinking at that time, so I need to get X, Y, and Z together. For a lawyer, they've just been seriously injured. They don't care about any of that stage. So when you first instruct a consultant in the case, you don't have very much evidence. And that's where the pre-action protocol really comes in handy for claimant lawyers, because you need to use that process to get the documentation you need to then approach a local standards expert.
Of course, on some more serious injury cases, if there's been a head injury, your client might not recall what happened. I've got a case on at the moment where the client sustained a brain injury. She has no recollection. The driver was fatally injured as a result of the accident. And at that point, it's police records and trying to get as much additional records, CCTV in that particular case was really useful because it captured the moment just of the collision into the wall. So just thinking through those bits of getting all the bits of information together is really important, and where you can source it from. And just as another tangent is getting a good lawyer in the country in question. That RTI I was talking about was in Crete. Found a great lawyer who was able to source the information, find out about the criminal investigation in Crete, and really help us build up that picture of what happened.
In the bigger cases, I imagine, certainly I would generally want this, in the bigger cases, by which I mean the multi-million pounds, in terms of legal advice, you may want someone who could handle things on the ground for you, but you may want someone else who's going to give expert evidence for you, because
You definitely need
first,
that. You need separation between the person who's doing the actual practical things on the ground for you and somebody who's going to be the expert. You need that separation for independence. Sometimes that's difficult, but you do need it.
yeah.
I think it's also important when you get to cost budgeting that you explain that, because you might be before a judge or a master and they'll say, why so much? And you'll need to say, well, I've got the lawyer in Crete. Do I need to find this out? That can't be our experts. And we need those two. But the important thing I find is the narrative to explain why.
I confess in that regard, I think we're going to miss Best of McLeod quite a lot.
Yes.
The Master Sullivan's pretty good at that, I think. Not sure I want to get in front of Master Cook on.
No comment.
Okay. I don't care. From the expert, you'll want someone, Ian, James, you want someone to talk about standards, won't you?
Yes. Yes. So it's a local standard. What a local standard is has been a question going on for years. Usually it's regulation, some form of law or legislation in that country, but often it isn't. In some cases, in the more far-flung destinations, there isn't that available, and then you start to look at customs. So what is a standard is an open question, but you need something to base your case on.
Or we're talking about slip resistance at the end.
It could be,
yeah.
But also, I'm trying to think of an example of custom. So,
I think I've got quite a good one. Yonks ago, I had a case of a gentleman who slipped on the forecourt in a hotel in Malta. It had been raining, had a conference with a Maltese lawyer. I think it was about time Malta was joining the EU. And I said, well, are there a standard? Because we know in Spain, for example, there are specific standards as to what the slip resistance should be in certain environments. And that's nice and straightforward. You get your pendulum, you find out what it is, at least in theory. And he said, well, it's a bit like the Wild West here in Malta. I know there's a lot of films filmed there, but I don't think any Westerns. And he said, there isn't anything. And I said, well, do you have a camera? And he went, yeah. And one of the issues we're going to have is, should there be maps out there? Should there be something to help with slip resistance? So we got Chris Borge, not to provide an evidence on the actual law. He took photos for us to evidence custom. And that was just what hotels were doing. And that was really helpful. And it helped settle the case. So you sometimes have to think quite widely as terms of what it is you need
In
to
all
look at.
seriousness, it's part of the picture that you are building up for the court and taking to trial.
Yeah.
And what are you going looking for as against the talk visa? How often will you be able to get accreditation, inspection records, licenses, things like that?
back to it.
There you all know.
Well, I think can we look to answer that.
I think
question?
they're minor with difficulty.
Yeah.
In fact, Lorna and I were having a chat about that in the last talk, and the problem is, of course, is that from a claimant perspective, you bring a case against the tour operator for certain documents, and they'll go, "But they're not ours."
Yeah.
And then you say, "But there'll be a contract, won't there?" And they'll go, "Well, but yes, but to what extent does it oblige them to be able to oblige the supplier to get the documents?" And even in cases where there is communication, it's the supplier understanding what they need to provide. And I will never forget doing a trial in Birmingham. I think it was a 3-week trial against Irwin Mitchell on food poisoning case, which I lot. Where
We heard defendant.
I was for a defendant.
Well, that's okay. It's good to
And
hear.
he was and the witness on day 2 of cross-examination found a whole bunch of papers and started waving them at the camera to say that he'd started to comply with his disclosure obligations.
He could be in the post office inquiry.
Yes.
Start it. Go on. Okay.
Yeah.
And also it's important at the very start, you may be settled in this case, but at some stage you might have to take it to trial. So everything you get, you're always looking how to build that picture up for the judge and what you're going to need to persuade the judge. So that's something you've always got in mind. What about causation? How often do you try and agree causation? I mean, there may be some technical breaches sometimes, but would it have avoided the accident is the question you have to ask yourself.
I think that's one of the key issues when you're looking at what you need to prove. So, for example, Greece is really good at prescribing when there needs to be a handrail, and depending on the width of the stairs. Now, if your client was walking down the middle of the stairs and was never going to make contact with the handrail, that's great that you've got a report from a Greek lawyer saying that there's a technical breach, but you've always got to bring it back to what extent would it have actually made a difference with regards to the factual nexus that exists. And likewise, if a hotel hasn't got a particular document that it ought to have had, you've just got to ask yourself, would that actually have made a material difference to the situation arising? And I think it's quite tempting sometimes, particularly I've noticed for some of the less refined local standards experts, to pepper you with every potential breach going. And you really need to focus in on what are the ones that are actually causative and relevant.
And you speak of local standards experts. Are we talking about lawyers or are we talking other people's spares and soft?
Depends on the case again. Mostly lawyers, but many architects, engineers, health and safety experts. It's what's appropriate for your case.
How high should a balcony be?
Yes.
That kind.
If I may add something on this, the lawyer or the expert may ask for all the documents in French and in English. Recently, there had been a debate on causation because of the lighting of the stairs. And initially, the solicitors was considering instructing technical experts to understand why the lighting had gone wrong, why the person had fell down the stairs. And it turned out that in the French translation of the witness statement, the French witness statements were poorly translated, and that the reason was that some of the occupants, for religious reasons, were closing the lights and shutting off everything on a Friday, which actually explained why the lights were going off. And this is something that honestly no one understood why everything in the building was off, and it was just a matter of translation because this element had not come out in the English version.
Obviously, the information you're going to need depends on the issue. And sometimes you'll be familiar or you'll have some familiarity because you've done an earlier case. If it's a country you're familiar with. So I guess, and I tend to do not the rule in both cases, is Spain and Greece, there'll be a degree of familiarity. Feel like I'm probably now to country as well. I'm going to ask other people.
Yeah, the amount of slipping cases in Spain that I've seen, I can't count. But so you do see the same kind of case again and again, and I like to think you get better at running them the more you do them. But you have your go-to experts. So yes, the more you go to particular people, particular types of cases.
But it has also, it can have an adverse effect, is that I know some solicitors, they would sometimes know the French law better than me. And then I would have them on the other side asking Part 35 questions. And I'm like, you know exactly what's the answer. Why? So I know you're doing your job, but and this is just, because I try to act on both sides for claimants and defendants. And recently it happened a few days ago where I have a questions clarify ahead of loss that's probably going to be part of Part 35 questionnaire. And I know perfectly well that the defendant's lawyer or the claimant's lawyer who's asking the questions knows the answers perfectly well, but he's still asking it in a very twisted way.
Because I remember once a conference being organised where you were our expert, and my solicitor is basically instructing me to give you what for, because we didn't like the answer. And you start the conference by you saying, so you're going to tell me I'm wrong. Now, fortunately, we discussed the case, that issue many times. And I thought, no. We're just going to allow you to explain this a little bit further. But that has its benefits.
That was quite a good impression.
Thank you. Well, I've heard it for many years.
What about changing standards? How do you find out about those?
I suppose a good expert who's on the ball and being aware that I think particularly in construction cases, that really is a time-sensitive issue. So it may well come down to when the building was built, when it was renovated, what is meant by renovation. I've had lots of fun in a case against Dan Clark talking about, what's the relevance of the date of renovation as to what standard applies. But it's really making sure that you've got an expert who is actually an expert on that particular issue and is alive.
And there are some experts who are from Part 35, but my instinct and my experience is that not everyone has the same rigorous code for expert evidence as we do. Is that sometimes an issue? You have to take them through exactly what's required.
Yes. Different jurisdictions have different approaches to expert evidence.
Duty to the court.
Yeah.
Something.
Yeah.
It's also the awareness of what needs to be in a report. There are certain countries out there where the experts seem to write a report by committee. That's not really helpful when going back to the point that somebody might have to be cross-examined on that report, and who's it going to be? And then our friends from Turkey who like to spend about 30 pages telling you about civil procedure in Turkey and a package case when it is not relevant. So the quality of and choosing the right expert for that reason is so important.
And I guess, James, and everyone, in fact, is that being in peer pool really helps inform us as to what we're going to expect in different jurisdictions.
Yeah.
As well as being a resource, it's that, I sat through so many of these conferences, sometimes with a big hangover, but you pick up things. Quite often, really. But you pick up things and you know who to call.
Yeah, I like to say that the key to this work, Gerard, is to have friends. You need to have friends, and GoPull is a fantastic way of making those connections.
I genuinely couldn't agree more. And I've been involved in international organizations, I suppose, more than 35 years, and I've learned a lot. So the American Bar Association is my sort of favorite home, and I pick up all sorts of things there that I've used in my practice, and that's really important to be involved and to go to these conferences and so on. It's a bit strange to go to Malaga on Thursday, because I understand that.
I enjoy it.
Yeah.
But Gerard, I think it goes beyond GoPull.
Because of Lisbon.
No. But for example, the amount of times you've been able to point me to an expert in a country that I wouldn't have expected, and within chambers, talking to people who don't do PI work, found me an expert in Kazakhstan. Wasn't expecting to do that, but our sanctions team do work with them. So it's just looking at all the various opportunities for where can you find someone.
Same with Irwin Mitchell. In the commercial, sometimes you can find contacts from the commercial side, and obviously our team. We've got quite a lot of people in our team, so there's lots of contacts that we've made over the years there as well.
And people know you as well. It's not just you knowing them. They'll know if Irwin's called, who's called. And what about unfamiliar countries? I mean, how do you start with an unfamiliar country? How do you start with Kazakhstan?
Find a Kazakhstani lawyer, I think, would be the first thing to do. And then, as we've been talking about, the key to this is what is your case? What do you need to prove to win your case? Do you need a Kazakhstani lawyer? Do you need a Kazakhstani architect? But the way through usually is speaking to a fellow lawyer who can then point you hopefully in the right direction. But that would be difficult with Kazakhstan, Gerard.
Yeah. Well, again, sorry, I'm not doing a complete encyclopedia of everything I've ever done, but I did a case about clinical negligence in Jordan. And in fact, my expert witness ended up being, he'd been on the Supreme Court, he'd been the Attorney General of Jordan. This was a good start, really. The defendant's expert witnesses were commercial lawyers. Mine was a criminal lawyer, apart from anything else. Since I needed to show that having a termination was not a crime in Jordan, that was quite helpful. But again, it's digging a bit deeper, isn't it? And just visualizing what it is you really need to prove. Yeah. Okay. How about technical issues? How often do you, again, going back to the experts, how often do you have to really probe an expert to see whether they really are an expert?
I think I've been speaking a case of Thomas and I did together, which was a zipline accident case. So Thomas was able to advise on what the general principles were, which is great. But where Thomas was absolutely on point, which is what we wanted in this case, was when he said, I can't talk to the technicalities of how zipline should operate and whether or not it was actually compliant. Some experts won't do that, and it's really appreciated when your expert does. And that's the point when we really assisted me when I went to court and said we need a zipline expert. And why? Because Thomas had said so. So it's then finding the right guy who at that point was actually a British-based health and safety expert because they were international standards. So we didn't actually need to go to a French expert there. But that was really helpful. It was really good collaboration with Thomas actually helping us to find the right issue.
If I may add one thing, and it's often, I think the real cornerstone of the instructions you can give is that very often we would see, and hence the need to speak at the beginning of the case. I would sometimes have cases where a lot of work has been done on the technical issues, and actually French law would not look into it, not because we are prehistoric lawyers, but because simply the obligation to trigger liability and compensation wouldn't look into that level of details. And so sometimes, I mean, in the case you gave, yes, we needed to go into that, but there are other cases, and we're going to come back to the RTA a bit later, but where, I mean, some ski accidents, for example, if you're using a chairlift, we wouldn't need to go into the technicalities. Or, for example, the slides when you go to the swimming pool, depending on where the accident happened. For example, if the accident happened not at the beginning and not at the end of the slides, but in the middle of it, in this case, looking at the technicalities is actually irrelevant in France. You've got a duty to compensate. It might be relevant in another context, whether you want to decide who's liable. RTA and seatbelt will come back to that in case of a bus accident, for example. But getting this may be relevant because that could avoid a long and technical debate. Because if you know that French law just says it happened at this moment in the water slides, you don't actually need to show the technical breach, then that's fine and that's enough. And knowing this actually simplifies the work, but also that's why I was talking about the communication that I think Sarah was and you as well, one of the first to really build on in the last 10 years, is that I think, Dan, you mentioned the commentary case, which is a case where I think it's one of the first case where I remember, because I'm probably 2012 or 2013, where I considered there was a real issue of discussion because there had never been a call, simply a conference call with the barrister and the lawyer and the experts, just simply talking about what's going on and where we're heading to. And that doesn't impact on our independence because I'm acting for both sides, but that really helps making sure we deliver something that's efficient.
And again, it will depend on the value of the claim. But from my experience, I think if you have an expert lawyer or anyone else, if it's a very high value claim, you may want to see them in person, even if it means flying out to see them and so on. I think there's no substitute for that. I mean, and Sergio, you were talking about the case of Roberts and Alamine, which I think was probably one of the social insurance schemes in Germany about 20 years ago. In a case called Trial Day, and it became more about non-delegate duty, really. But it was about German providers providing services to the English forces in a similar way, but it was obstetric negligence. A world away from hackers travel, but you have to see the obstetric negligence in the basis of the standards in a German hospital. And actually, some of the obstetric techniques they used were different. And I remember having conferences individually and going to see the German, all very precisely to get through it. Again, more challenging in more modest claims. James, how do you deal with it? If you've got a £200,000 claim, how do you deal with that? You do the best you
It's
can.
increasingly difficult, isn't it? Government's not making it easy for us.
No.
Hopefully there'll be a change.
Inviting us to rugby on the weekend.
Yeah. That works well.
But sometimes we would also make the effort of saying, let's imagine you have a few cases you work together
You
on,
can put them together.
and just say, and for us, it makes our we have so much less work by, sometimes just coming for a day in London, having 5 meetings, 6 meetings, and that's easier.
And that works far better.
I think
So much better.
key thing with costs in the Irwin case is building up that narrative, because a judge will, who's say not, for example, familiar with the need, and which we might get onto, and why you might need 2 local standards experts, one, say in Spain, to say what general duty is, and the other technical to say what the condition of the floor was. They'll look at it and go, well, don't you just need one? And it's the importance of explaining why. It's the importance of maybe a skeleton argument, saying what Lockheed is before they see the case, or explaining why you need an agent as well as an expert.
How often is that an issue between a district judge or a master before and a district judge or a magistrate?
Constantly.
Yeah.
It's a constant battle. It's a constant battle, and I think, and sometimes it's not the battle I tend to find between sensible litigants, sensible claimants, and defendants. You'll very often have a case where, for example, both sides will recognise, particularly in foreign law cases, there is a range of opinion, and why certain things are done, and the parties will actually be generally agreed as to the way the case should be run properly. But if you've got a judge who is fixated, as they are instructed to be, on proportionality, it's reminding them that the case still has to be run properly and justly, and that's the real issue.
And it's tangential to this, because this is domestic rather than commercial. But the masters, for instance, say so often, and in fact, I find defendants say so often, that if you want a care expert, you don't need a care occupational therapy. One person can do both. And so you then come to trial in front of Mr. Richard, because an occupational therapist shouldn't be given evidence on care. And it's a parallel problem, but similar in a sense.
Yes.
Yeah.
Okay. We've talked a little bit about this. So sourcing experts, I mean, we bring you in. That's the best idea. That's one source. If someone wants an expert, ring counsel. But James, in Irwin, you've got a great number of people, a great deal of expertise. It's cross jurisdictional and so on. So you would start in-house.
You would start there, and then you build out from there and see your connections through Purple, etc. Barristers like Ian, like you, Gerard, and we that's the way we usually do it. And most of the time, that's successful. I've not actually had a case where that's not been successful, but that's usually the way to do it. Sometimes it might be. We had a case recently involving an accident in Lithuania, not knowing a Lithuanian lawyer, but knowing somebody in Sweden. We went to the Swedish lawyer, and the Swedish lawyer was able to appoint us to someone in Lithuania. That's sometimes the way we do it. Yeah.
Well, and again, so Cheryl and I know that it's not easy to get hold of a care expert in America. And, I know a lot of American lawyers, and they do it typically in a different way. And to get them to understand what we're looking for is not always easy. My wife's a care expert. I've been suggesting she should be taking over the consultant. More news soon, we'll see. She tends to run her own business, doesn't like me. But you bring out Templewood. We've got quite a network. We have a view, and we have a WhatsApp group and so on, which isn't just dedicated to providing that drinks sometimes. It's a closed group. What about CVs and qualifications? You need someone who's just not an expert, but who is demonstrably an expert.
This might be a debate between Ian and I on this point. You need an expert. In my view, you need an expert, not somebody who's pretending to be an expert. Analogy would be, I can't read Loi Bodinter and say I'm comparable to Thomas in French law, although apparently Thomas thinks some lawyers would be. For my view, you need an expert with a CV which shows that he or she is an expert, somebody who's researching and using that research to try and pretend to be an expert isn't good enough, in my opinion.
And if I may add that the CV needs to be updated with other means, with mentioning la conférence. La conférence, which I passed in 2012, gives you for 1 year access to criminal law cases. Okay, so we are far from what I'm doing today, but I basically give you trial experience. You basically import everything. And about a couple of years ago, I was cross-examined, and the barrister actually started on this to criticize my qualifications, not having discussed this with his instructing solicitor, whose firm actually instructs me on a regular basis. So they stopped immediately after a few minutes because I said, you know, I'm happy if you criticize my expertise, but your instructing solicitor is probably doing the same mistake very often. But actually the mistake was on my part, not having provided a CV that was detailed enough to explain this, which is, I think, a difference with the UK in the sense that we are a little bit less specialized. So, and that's something that I think could be a source of criticism, but also a source of misunderstanding.
Well, I confess that in Baker, Sarah Crowley may remember, I was embarking on the cross-examination of the defendant's expert about what exactly he knew about what the Supreme Court of Spain would do in a particular instance, to be tapped on the shoulder by David Sanchez. He's there every week.
Yeah.
We backed off. Okay. Let me jump to Thomas a little bit. We touched on it there. How difficult is it being an expert on French law in the English courts?
Well, I work in a family firm, so hopefully that helps. No, more seriously, I thought that there's been two points that I wanted to convey. The first one was to ensure we've got this dialogue that is constant, that is constructive, where we have the information. And you know, I think that is a key point. The second point, and you will allow me for 1 minute to be a bit more precise. The reason why we did not produce slides, it's not because I am on strike, but there was one decision I wanted to mention, and it hasn't been published yet. Behind every facade lies a hidden vulnerability waiting. This is P.D. James in The Death of an Expert Witness. Le reste, c'est de la littérature, dit Alexandre Dumas. I'm quoting P.D. James because basically the meaning of this is, let's look what's behind, let's look in details. And I'm going to tell you about a very bad experience I had, where I'm probably, in a way, part of this this mistake, and the decision will be published. I think it's a court order. I'm not sure it's going to be published, but let's see. Basically, in some cases, I could see that with the other expert, at the moment of the joint expert drafting report, there might be conflicting instructions, not the same instructions, or that the other expert wouldn't have the same evidence. So I think this is where your expert is to be proactive and check that actually we've got the same evidence, we've got the same. But then we've also had the issue of the court order. The court order is not always provided to the lawyer. And in one case, it wasn't provided to us. And the wording of the court order was the following: a medical legal report from a French medical legal expert. Does that allow me to get, as a French law expert, a medical expert, French law medical expert, instructed to comment on at least some of the heads of the claim? It is a very complex case where complex accidents, the person is then hospitalized, had a choice between different surgeries, opts for one surgery, goes horribly wrong, and then they decide quite cleverly to issue proceedings in the UK, which raise an issue of whether they should get the hospital involved. If the claim had been brought in France, the law is quite simple. You sue the main insurer, you get the hospital in the proceedings, but then it's up to the hospital to turn against, sorry, the insurer to turn against the hospital. In the UK, they just decided to do against the insurer, and you do what you do. We were not provided with the court order. Very recently, I just had the exact same problem, and I said, can I get the court order? And finally, both parties agreed to say, it's badly worded, it is super complex, so let's allow each expert to get a French medical expert to comment simply on the general damages, to give evaluation, which I'm not able to do, something that is not binding the court, and something that is merely a commentary. No speculation, no analysis, but gives us some guidance. one of the issue I had is how I comply with my instructions without getting these French medical experts. So in my view, I'm right to do so because if I'm doing that, I can't do my mission. But I ended up having my report being challenged and my report being struck out, which is quite annoying. That's the way it is. That's why I was hoping to get the decision to see how it's drafted. But it was a good, I would say, lecture for myself because usually I get everything. So I ask for, give me all the pages. But in this case, we were not provided with the court order. And it's, I don't know if it's the same judge, but it's recently we had the same case. And usually it doesn't happen this way because everyone, you know, would just say, we know there is an issue. I've had the case recently with two of the firms who are present here. Everyone agreed to say, we can't do the job. We need, you know, we agree to this interpretation of the court order is right. In this case, that was a law firm that I think was not really doing this kind of case. They made the application and was successful. So I think that's my second point, is to don't hesitate to put a bit of responsibility on your experts, to give them everything. We can ask questions. Of course, procedure is different. And that's my last comment to answer your question, is how procedural law impacts on our work. The whole mutuelle de Poitiers decision for sometimes was quite hard to process. But conversely, in a very recent case that gave rise to a type of decision which I think is completely fair, but could not have been reached in the UK. It's a victim of inhalation of fumes, someone who's been badly impacted from a medical point of view. The issue was not whether his condition was fraudulent, okay, we're not talking about fraud, is that the insurance solicitor had an issue to say, is he doing a bit too much compared to his actual condition? They got a private investigator. They basically went on Facebook and all that. This is procedural evidence that would not be admissible before a French civil court. So I'm giving you this example. So we're not talking about fraud, but this is the exact type of case where the articulation between French law and English procedural rules, because on evidence, you know, you remember the movie 2001 with the monolith. We think on law and evidence, the French, they're a bit like this. You're like monkeys around it, but you're much more sophisticated. And I'm taking this example because that led, and I think it was settled at the end, but that led to results where you could get an assessment with evidence that would not be admissible with a civil court, while French law was still applicable to quantum. And that's the type of things where you need to have those discussions. And it's not about, we're all conscious about costs, but that was just a matter of having a call or having a meeting.
By the sound of it, people need to come and talk to you properly before they get to the stage of having to deal with directions of case management client.
Exactly, definitely.
Serious point.
On Thomas's 2 points, the second.
It's not the one. It's another case.
The point in relation to the French medical legal expert and the difference in the procedural rules in England versus it's been a thorn in claimants, lawyers, and everybody's side for some time, because, as Thomas says, the Wall Mutual decision basically says we shouldn't be having French medical legal experts in our cases. But on Thomas's side, is you tell us, Thomas, but isn't the law in France that if you were to give advice on the issues that you need the medical legal experts, for instance, the point system of the Gentiliac system, it would be illegal to do that in a report?
If I do that, I'm basically committing an offence.
I think it's the most fascinating area, one of the most fascinating areas in cross-border law, is how to quantify a French law case. Yeah. Because you're right, you've got Wall Mutual, there's a Lithuanian-sounding unreported name, I know Chris Deacon's written an article about from a master, which has said absolutely, for I think a Belgian case, absolutely no way can we have medical legale. But in certain cases, it's custom and practice to get the report as suggested, but the lawyer can still take you through the tables and explain things. In other cases, you've got the lawyer saying, I can't do this, but you've got the possibility of a judge going, I don't want some medic just giving me the answer. And even if you get the criteria, how do you explain to a neurologist how it fits within the criteria, or whether or not the injury is the scarring is a 4 out of 7 or a 7 out of 7? They've got no idea.
And all the time looking at the cost of it.
Yes, which goes back to the narrative. The judge who just goes, just get an answer for us, and it's not that easy, is it?
Thomas, does it make your job easier, the fact that you're admitted in Wales as well? Does your experience just to help you understand doing expert evidence in English cases or cases?
To be frank, it only helps. First, I'm careful not to give any advice on English law, but it helps with cost. It helps with understanding. For example, you talked to me about Part 36. That's what I get. That's what, and I
Part
think
35.
Part 35 also, but Part 36 as well.
Yeah.
And I think it just helps the mechanics of how I would do my job.
Yeah.
And you know, and how I would address your question. When I said that I run the whole bundle of documents and the court order, is simply now sometimes I'm thinking maybe might give something that is probably addressing your concerns more or your expectations.
But I think the other point is that your experience beyond that of knowing how your evidence will be received later on down the line, storing reports, evidence at trial, all of those factors is really helpful, because you do get some authors of expert reports who really don't understand the context of why they're writing their report.
So I completely parted from the script you gave. You gathered that when I jumped around. But they have walked on the script, so do I. You don't. But we're going to talk about a section that says tricky cases. Let's see if we can have some fun. The tricky cases. What do you do where there are no formal standards dealing with custom? Ian, you've got an anecdote, I tell you.
Well, I've told a story about Malta, but I think one of the particularly really interesting cases when we were preparing this and we were talking it through is the crossover between standards and applicable law, because you've got cases where, again, certain experts will write reports or package cases and it will just be full of domestic law. This is the tort law of Turkey. This is what the court in Turkey does. This is the evidence that's admissible to Turkey. And they may even say, and I don't even believe the evidence, real alarm bells there. But there are some cases where there's not going to be a fixed regulation. So the CTE in Spain, which says the floor needs to be like this. And it's more going to be a bit like a domestic slipping case or something like that. Well, it's got to be reasonable. Well, what on earth does that mean? And that's where you do probably go and look at the civil code, or you do look at case law. And then there's interesting arguments there as to whether or not the case law is binding or indicative, depending on whether or not you've got a civil law system. Dan and I fought an interesting case about 2 years ago about a woman who was not at all drunk, but lost her balance going down a slope and ended up putting her hand through a glass window. And my fallback argument is the glass should never have shattered, but there was no standards on what the thickness of the glass should have been. And that's where we were looking at case law. And I think Dan's main argument was, and I can't see if he's still here, was what a load of nonsense, Ian. And mine was, this is very relevant. But I think those issues of the interplay between what the law is in terms of establishing what the principles are, but not going forward completely, as Thomas was talking about. So say you've got a seatbelt, maybe this is a good time to talk about the seatbelt case.
Yeah, I was going to go move on to
Yeah, that's a good example.
Standards.
Before we get to seatbelt, though, I think we should talk about Morgan and Toohey very briefly.
Yeah.
Morgan and Toohey is the key court of appeal case on this issue. And I'm not going to repeat the whole case, but essentially, in that case, there was no direct applicable standard, and they were doing their best, well, the judge was certainly doing his best, good on him, to try and find some kind of standard to apply. And he tried to, what he did in that case was to apply an international ISO standard. I think that's what you need to do in these cases. When there is no direct applicable standard, you need to do the best you can to try and reduce some evidence as to a standard.
And a judge in the world will fall back on his or her experience,
Yes.
trying other cases and borrow that.
That's exactly what happened in Morgan, yes, yeah.
I mean, actually, you could say that about contribution in English, but you couldn't. You may be applying Spanish law or Portuguese law, but once you know you can find comparative faults and it's open, my experience is that judges will tend to use their English experience to come to a decision.
Well, I think there's maybe that tension with what Tomlinson said in Lockheed
Yeah.
with regards to the need to have the local standards evidence. And I think he said the claimant who proceeds without it does so at their peril. That at what point can you imply by local standards that you need that there in black and white? The judge can't just assume or shouldn't assume based on what's said in Lockheed. So you still need that evidence, but it's finding the equivalence from, say, that international standard rather than domestic standard, or looking at what principles are from domestic law and how they might tie in as well. But you need something. If you run a case now, apart from the egregious breach, the one I always think about would be driving on the wrong side of the road. But again, that might depend on what country you're in as to whether or not that is the breach of local standards. But you need something. So think
Breach in most countries.
I've learned not to make assumptions.
Seatbelts.
Seatbelts. What about the interplay between standards and domestic law? So let's take seatbelts in France.
The understanding when we prepared this panel is that we talked about the relevance of seatbelts. If you're a passenger in the car on the French law, whether you're actually wearing a seatbelt or not, is part in some except rare cases, it's actually irrelevant with respect to your rights to compensation. However, and we've had a case with a few years ago where I could see the English solicitors being really, really concerned about getting the evidence on who was wearing it, whether that was functioning, and whether that was relevant. And actually, it became relevant in one respect, is that the victims were going with part of a Club Med tour, and as part of the Club Med tour, the travel with the bus was subcontracted to another entity, which the issue was whether their bus was correctly equipped and whether they had given instructions on whether to wear seatbelts and whether they had done the necessary checks. And of course, this was relevant not for the compensation of the victim, whether they were wearing it or not has absolutely no relevance, but that was relevant on the counterclaim by Club Med against the company who organized the travel. And it's simply that I think when we did the expert report, the other side had not fully understood this, which led to a report that was badly drafted because that issue wasn't addressed. We're talking about the seatbelts, not because it impacts the victim's right to compensation, but because on the insurance side, that's probably going to have quite a huge impact on counterclaims or the negotiation that's liable between the various insurers. And I just remember seeing the other side lawyer just telling me, I don't know why they're asking me again and again and again about signals. And it turns out that we had a conversation with the barrister just to understand that that was the mechanics behind that. And that's typically the type of standard where it's super relevant for you, but if you keep the local experts out of the loop, it's probably going to get a bit annoyed saying it's irrelevant. Well, actually, it is for the right reason, but those need to be, I think, expanded or clarified, and that also avoids going into the wrong direction, where one of the report drafted in that respect was constructing strange theories, saying this person was not wearing a seatbelt, and then talking about the victim's contributory negligence, which in French RTA case is clearly never happening. But that's, and that was creating, I think, legal uncertainty. Because
that's the fascinating point. I think that if you've got, say, a coach crash case and pre-Brexit you've got an Odenbright case and you can rely on loi Badinter, all you need to prove is the causation. You don't need to prove the breach. If it's a package case, you've got to prove that the conduct of the driver was unreasonable. So you're having to prove something which you wouldn't have to prove under French law. And then we're asking you what's reasonable or not, but you think, well, under the wide and tear, that's irrelevant. Or under the seatbelt with the causation bit, that's irrelevant. And I remember having a case where the driver just lost consciousness through no fault of his own. The case under the medical condition, he just was very ill suddenly, and we looked at it and went, I'm a package case, and we're not sure we've got a case here. But under live and tear, fortunately pre-Brexit, great, we did. But those two, it's the same case, it's the same facts, but they're being dealt with really differently. And we're asking an expert in French law to comment upon what's reasonable when French law doesn't consider the question of reasonableness. And I think that's something that we all need to be really alive to.
I think what in the package context, what's interesting, I'm not sure this is the case. I'm sure there is a law in France that permits use of a seatbelt. Yes, we'll say there wasn't in a far-flung destination, but the custom was that everybody in that destination was wearing a seatbelt. That is the custom. That is the standard.
Okay. Can we just wind up really by looking at some practical points about the report? Item 5 in my description. I mean, this applies to expert reports as a whole. The key thing, I think, whether you're dealing with a domestic expert or not, is that the expert knows it's their report. I can't overemphasize how important it is that. Ian, you see the work with experts. The final conversation in any conference is, at the end of the day, this is your report, it's your reputation, and you're giving evidence. And actually, the witness box can be a very lonely place when you're giving evidence as an expert. That's more acute because my wife is an expert, but it's something that I hope I've trained every pupil, legal assistant I've ever had. So, how do you deal with Part 35 with experts who may not be familiar with it?
Again, it starts off with letter of instruction. You need to tell them very clearly what is required if you want to accept instructions to be an expert in the English court. That's in terms of their duties to the court and their independence, but also in terms of the formalities, what's needed actually in their report as well.
And you follow up with phone calls.
Yeah, that's the start.
These are requirements, but this is what it means, and it's your report.
Yes.
And you have to emphasize, I'm guessing, that they're not an advocate, they're not a lawyer, they're not an investigator, they're not a lawyer, either they're legal. They're not trying to give the answer to the case.
Yeah.
So Ian and I had that in the case of Brinson and Johnson.
I think in certain countries, it's really important just to emphasize the ethics of that. I have had nightmare stories of lawyers in certain countries going off and unilaterally talking to their counterpart on the other side or looking for, and that's a huge no-no, but it happens. And sadly, for some of them, because they think they're being helpful, but actually they end up being kicked off the case.
And actually, it's not what a judge would do in their country, it's what a court in England and Wales will do, given the rules that there are.
Yeah, we've had a similar situation, not me personally, but in Mitchell, a similar situation where a defendant expert went off and bypassed the lawyers and spoke directly to the insurance company in the jurisdiction who they had a relationship with and sought to produce a settlement offer as a result. So it's making sure your expert knows what they're supposed to be doing, what they're not supposed to be doing.
That wasn't me.
It wasn't Thomas, no.
Conferences, you'll want to test evidence, you'll want to ensure that their evidence will be challenged, and you want to make sure that the experts got sufficient time to prepare for the conference and all the materials that are necessary. Yeah. What about agendas and conference notes? What do you think? How important are they?
They're really useful, particularly more complex cases. 8 memoirs afterwards, as a reminder of what's required, and just being clear. And I think one of the things that's also important to remember, because however brilliant Thomas's English is compared to my non-existent French, is to remember that most of our experts are not what they're speaking in their mother tongue, and to be there a little bit extra clear. And I think also with trial, reminding the expert that whilst again, in a conversational sense, their English may be impeccable, giving themselves the opportunity to have an interpreter.
I was going to touch on it.
It's really important.
I have taught a number of trials where people say they are good English. And actually, when I've been at all worried, I've had an interpreter. There is no substitute for it. so that it can be clear what is being asked and what is the answer.
I think it's really important not to forget the aspect of fatigue. That again, for a 10-minute conversation, maybe even a couple of hours, speaking in a foreign tongue might be fine. A full day of being cross-examined by some really sharp silk, you might want to give yourself a little bit more energy.
And it might also be very damaging for the judge because me, as the day go by, my French accent increases. It could be very annoying.
It's been okay so far.
When I was just starting and I didn't know if I would join Clayton's, I went to one of my professor, Peter Roth, who's a KC, and I asked him, should I become a barrister or a solicitor? And he said something, and I praised him for that because he was quite a very tough answer. He said, he's at Brick Court, and he said, you should not become a barrister because you'll never master the language. And I think he's absolutely right.
I don't believe that.
No, I think he's right because in terms of questions and answering, and I can't forget that because the nuances of the questions or the nuances of my answer would take probably a few generations of living in London and drinking, like to melt it. But I know also that some French experts would also get a translator because it gives you a bit of breathing space. And I think it's too important. I was talking about mastering the language. I think it's important. The last point that I wanted to mention on that, it happened to me this summer. I was supposed to go to a trial, Milton Keynes, and I realized that the other side's solicitor expert had done his reports without the last version of the schedule. And I think it's simply that some of the data have not been updated. And he's an expert that I really, really like. So I respect, and I gave him a call for that. Finally, the parties settled. What I mean by that is that getting all the information in advance, please, not the night before, really helps our lives.
Ian, James, we've got overrun a bit. That's deliberate. I know that the bar may have built to a little while. But do you want any closing remarks on the use of experts in case of errors?
I think it's all about proper collaboration between the whole legal team, and they're not leaving great big gaps so the expert doesn't know what's going on, or counsel. And I think that does put a lot of the heavy lifting on the solicitor. But I think the more of a team,
And spoon feeding without being spoon feeding, making sure they've got everything they need.
absolutely, and just I think just that working as a team, making sure we've got the right experts, and just the problem is on both sides of the fence is proportionality. With defendants in box cases, it's what we're going to recover, if anything. From a claimant's perspective, it's limited budgets.
Even in a multi-million-pound case, people take the report.
James, if I could summarise our talk in relation to local standards evidence in 2 words, in all circumstances, get it.
Yeah.
Well, thank you each of you. I've enjoyed moderating that. I say so. And thank you for the crib sheet. I'm sorry to put you through your pages by jumping around it a little bit. There were some worried looks at me and saying, "What page are you on there?" Imperceptible to you, I know. Thank you so much. Get the first conference. Can I first of all say thank you to all those who came and spoke for us. We'll be back again next year. That will be our 6th, if not our 7th. Thank you very much for all watching.